Some time ago, I filed an employment discrimination lawsuit on behalf of my client. She alleged she was discriminated against, among many things, based on her disability. And once I got into the case, began to conduct discovery, learn more about the characters and the facts, it really read like a soap opera, really. I mean, there was inter-office turmoil. It was he said, she said type thing. They were literally name calling each other, and they just plainly didn't like each other. At least that's what it appeared. And my client was terminated by the employer, and she alleged that the co-workers influenced her termination. And that's what we're going to talk about today, stray remarks. So let's get started. And to help me illustrate the stray remark doctrine, we're going to look at a case here. Luka versus Bard College et al. Stray remarks are statements made by usually a non-decision maker, coworker, or supervisor about an employee's race, sex, age, national origin, or other status that are offensive but do not represent harassment or discrimination by the employer. So let's look at the prima facie elements, and you'll find these elements in the case that we're going to review today. To determine whether a particular comment is probative of discriminatory animus or is a mere stray remark, a court considers the following. One, who made the remark, for example, a decision maker, a supervisor, or a low-level coworker. Two, when the remark was made in relation to the employment decision at hand. Three, the content of the remark. And four, the context in which the remark was made, for example, whether it was related to the decision-making process. And we will be looking at each of these individually later on. Now, there is an exception to an employer's liability in these cases. An employer may be held liable for discrimination based on the discriminatory animus of someone who was not the ultimate decision maker, but who intended by his conduct to proximately cause the adverse employment action and did, in fact, cause that employment decision. And I wanted to introduce you to three characters in this story: Mr. Botstein, Mr. Scalzo, and Mr. Domini, besides Bard College. And we'll get more familiarized with them later on. So in 2003, Bard College hired Barbara Luka as an assistant professor. At her pre-tenure review in 2007, Mr. Scalzo, a professor and former chair of the psychology department, recommended her for reappointment and gave her a positive evaluation. Then, sometime the following year, Mr. Scalzo became aware that plaintiff was a lesbian, and his attitude toward her became actively very hostile. After leaving Bard College, plaintiff learned that Mr. Scalzo regularly, and that's important, he regularly referred to her and her partner as a B word. And on one occasion commented that plaintiff seemed like she was having a hormonal surge. That's important too. Now, plaintiff first stood for tenure during the 2009-2010 academic year, and she garnered broad support from faculty across the college. She learned during the course of her tenure review that Mr. Scalzo falsely and maliciously told faculty members, including those in positions to evaluate plaintiff's tenure application, that plaintiff was mentally unstable, and told others in the psychology program that plaintiff was crazy and did not deserve tenure. At the time plaintiff first was evaluated for tenure, Mr. Scalzo was the only active tenured member in the psychology program. Mr. Scalzo also served as the division evaluator for plaintiff's tenure process, in which capacity he gave her a negative recommendation, falsely claiming that she was not collegial with members of the psychology department. Mr. Scalzo recommended against plaintiff's tenure, and Mr. Dominy, then the dean, adopted that recommendation. The college then commenced an investigation against Mr. Scalzo as the result of another employee making a sexual allegation complaint against him. The investigator interviewed plaintiff, Luka, the plaintiff in this case. After plaintiff's interview with the investigator, Mr. Dominy began to act hostile toward plaintiff. In particular, when Mr. Scalzo went on sabbatical in the fall of 2011, Mr. Dominy appointed two of plaintiff's junior colleagues to run the psychology program, rather than plaintiff, who was the most senior faculty member. By the way, I didn't say earlier that the plaintiff is a scientist. Plaintiff believes this negatively impacted her 2013 tenure application. So during discussions of plaintiff's tenure review in 2013, plaintiff did not receive any votes in favor of her tenure. Plaintiff requested that the Faculty Evaluation Review Committee, or FERC, overturn the negative tenure recommendation and expressed her belief that the negative recommendation had been tainted with discrimination and retaliation. Finally, Mr. Botstein, the president of Bard College, reviewed plaintiff's tenure application. He too concurred in the decision to deny plaintiff's tenure. Plaintiff attempted to appeal Mr. Botstein's decision to Bard's Board of Trustees, but they denied her request and affirmed the tenure decision. After plaintiff's employment ended, she learned that the college sought to replace her with someone younger. She also learned from a review of the Bard website that all subsequent hires by the psychology program were male. She sued Bard College, Mr. Scalzo, Mr. Dominy, and President Botstein for discrimination based on her age, gender, perceived disability, and sexual orientation. The defendants filed a 12B motion to dismiss, alleging that she has failed to state a claim upon which relief should be granted to her. Now, to best illustrate the stray mark doctrine, moving forward, I'm going to focus on plaintiff's gender discrimination claim. But I included all of these characters and the information because I wanted you to get a general understanding of what plaintiff's lawsuit is about. Now, we said we were going to break down each element in terms of deciding whether the remark is straight or not. One, who made the remark? For example, a decision maker, a supervisor, or a low-level coworker. Remember the rule? An employer may be held liable for discrimination based on the discriminatory animus of someone who was not the ultimate decision maker, but who intended by his conduct to proximately cause the adverse employment action and did, in fact, cause that employment decision. Does anybody come to mind? Well, I submit to you that Mr. Scalzo's conduct meets this definition. And you'll see what I mean. Prima facie element 2, when the remark was made in relation to the employment decision at issue. Now, the court recognized that in 2007, Mr. Scalzo gave plaintiff a positive evaluation. That's critical. And it also recognized the following year after he learned that she was a lesbian, he consistently called her and her partner the B word. This continued leading up to her 2013 tenure application. So element 2 has been met. Element 3, the content of the remark. The court noted that Mr. Scalzo regularly referred to plaintiff and her partner as the B word. It also recognized that Mr. Scalzo engaged in gender biased conduct in connection with a complaint by another female, Miss Darling's tenure application, and sexually harassed Miss Gershoni, who the investigator interviewed. Itself, the court held, is a form of gender discrimination. So, element 3 has been met. Element 4, the context in which the remark was made, for example, whether it was related to the decision-making process. The court opined calling plaintiff or her partner the B word and making a disparaging comment about plaintiff's hormonal surge could very well be considered stray remarks. However, the court continued, plaintiff alleges that Mr. Scalzo regularly referred to her as the B word. By definition, then the comments made earlier occurred in time to plaintiff's 2013 review. The court found that plaintiff alleged a plausible gender discrimination claim and it dismissed the defendant's motion to dismiss. And the point in the story is that even though Mr. Scalzo was not the ultimate decision maker, his influence in the college denying plaintiff tenure was motivated by discriminatory animus based on her gender. Therefore, his comments, name calling, were not stray remarks. And if in the end the court finds merit in the plaintiff's claim, the employer, Bard College, could be liable for discrimination.